Welcome back to the next installment of the channel. In this new series on SSI and SSDI disability issues, we're focused on helping you truly understand the rules, the forms, the updates, and how policy shifts could shape your case. If you have questions about your specific condition, your claims progress, or how age and work experience influence your eligibility, drop a comment below. Your feedback directly shapes future episodes, so we really want to hear your real-world experiences. Today's topic is especially crucial if you're age 50 or older. Many people have heard that being over 50 brings certain advantages when applying for disability. But what happens if those advantages are changing? In this video, I'll break down the medical vocational grid rules, explain why age categories like 50 to 54 and 55 plus play such a big part, explore what potential updates could mean for new and continuing claims, and share what you can do right now to protect yourself. Stick with me, because understanding this could make a meaningful difference for your benefits. When you apply for disability benefits and reach step 5 of the evaluation process, Social Security looks at more than just your medical file. This is where the medical vocational guidelines, often called the grids, come into play. These rules ask, given your age, education, past work experience, and your residual functional capacity, meaning your maximum ability to perform work-related activities, can you reasonably adjust to other types of jobs that exist in the national economy? The grids are structured tables that match those factors. Depending on where you fit within them, the decision can lean toward disabled or not disabled. The age categories typically look like this: under 50, younger individual 50 to 54, closely approaching advanced age 55, and older, advanced age. How your age group interacts with your RFC and work background is often the deciding factor. For instance, imagine someone who's 52 years old, previously performed only unskilled work, and now can do only sedentary activities. With no transferable skills, that person may meet a favorable grid rule simply because they fall into the 50 to 54 category. But if that same person had prior skilled work or transferable abilities, the decision could swing the other way. The logic behind the grid system is that older workers generally face more barriers, fewer job openings suitable for their limitations, and greater challenges adapting to new roles. So, age is not just a statistic, it's a key factor in the overall evaluation that determines your outcome. If you're 50 or older and applying for disability, these guidelines recognize that you may have greater obstacles returning to work than younger individuals. People over 50 often find retraining harder, face health setbacks more frequently, and may have long-standing work histories that make career changes difficult. That's why the categories closely approaching advanced age, 50 to 54, and advanced age, 55 plus, receive special consideration. For example, a claimant limited to sedentary work who's 52 years old has only unskilled job experience, and no transferable skills will likely see a much higher chance of approval than a younger worker in the same medical condition. This happens because age is one of the 4 pillars of the grid. Age plus education plus past work plus RFC equals decision outcome. 2 claimants with the exact same medical issues, one age 45, one age 52, could end up with opposite results simply because of this age difference. That's why it's essential that your file clearly documents each of these 4 factors. A complete, well-supported record increases your chances under the current rules. On the other hand, missing or unclear details about your age-related category or job history can lead to an unfavorable outcome. Let's put this into context with recent regulatory updates. In April 2024, Social Security made a major change, reducing the relevant work history window from 15 years to 5 years. That means older jobs, especially those you held a decade ago, are now far less likely to count as past relevant work. At the same time, the agency tightened exclusions for very short-term jobs lasting under 30 days. These changes already shift the playing field. For example, A 52-year-old who hasn't worked in 10 years may now have a stronger argument under the revised rules. Another significant change: the factor of inability to communicate in English was removed from the education categories to reflect the realities of today's labor market. While these updates didn't alter the age brackets themselves, they demonstrate that Social Security is actively modernizing how vocational factors are considered, especially for people over 50. In other words, the system is evolving, and staying informed is your best defense. Some legal experts and disability advocates have noted that the agency is currently studying additional reforms related to how Step 5 vocational evaluations are performed. Potential updates may include redefining transferable skills in light of automation, revising age ranges, and updating job data to better reflect real opportunities for older workers. But let's be clear, these are still proposals and research initiatives, not finalized regulations. Until an official Notice of Proposed Rulemaking, NPRM, and a final rule are published, the current grid rules remain in effect. For now, that means, don't assume the rules have changed yet. Prepare your evidence as if they could. If a new rule does take effect, it will generally apply only to future decisions, not retroactively to older ones. So what would happen if the rules were tightened? Let's imagine Social Security shifts the favorable age category upward. For instance, moving closely approaching advanced age from 50 to 54 to 55 to 59. Under that new framework, many people who are 50 to 54 today could lose the current age-related advantage. That means the burden of proof on medical and vocational evidence would become much heavier. More people age 50 and up might face not disabled findings at Step 5, unless their medical and vocational records are extremely well documented. If such a change occurs, it will most likely impact new applications filed after the new rule's start date. Ongoing disability recipients could also be affected during future reviews, depending on when those reviews take place. For now, your best move is to build a complete detailed record under the existing system. Timing matters. If you file now, your case is judged by today's categories. If you're already approved, make sure your evidence stays current for your next Continuing Disability Review, CDR. Always check each new rule's effective date to understand whether it applies to new claims, ongoing reviews, or both. No matter when you file, strong documentation is your best safeguard. If you're over 50, make sure your file includes detailed functional capacity assessments from your treating doctors describing exactly how long you can sit, stand, walk, lift, or carry. Notes on how many breaks you require, how many days you miss, and your expected off-task percentage. Vocational statements outlining your previous jobs, including tools used, pace, supervisory duties, and skill levels. Explanations of how your age and time away from work limit your ability to retrain or adapt. Your medical records should show how your condition progresses, how treatments impact your daily functioning, and why your ability to adjust to new work has decreased. Don't rely on simple statements like, "My doctor says I can't work." The evidence must show objective findings that back up your limitations. When your records clearly tie your RFC and vocational barriers to your age category, you stand the strongest chance of approval. For example, age 52, limited to sedentary work, unskilled background, no transferable skills equals no available work. If Social Security releases an NPRM in the future, you'll have the right to submit public comments before any final decision is made. To stay informed, check the agency's regulatory action listings and set alerts for terms like medical vocational guidelines or vocational factors. Once a proposal appears, take note of the docket number, comment deadline, and submission process. Your feedback can include your personal experience as an older worker, examples of how job markets have changed, and the challenges you faced adapting to new work environments. These public comments matter. SSA reviews them before finalizing rules. So if you see a proposal, Act promptly. Share your story, describe your limitations, and make your voice part of the record. Whether you participate in the comment process or not, continue strengthening your evidence file. That preparation benefits you no matter what happens next. Let's address a few common misconceptions. If I'm over 50, the grids guarantee approval. False. The grids only work in your favor when all four key factors, age, education, past work, and RFC, align properly. Age helps, but weak medical evidence can still lead to denial. The 50-plus advantage is already gone. Also false. As of now, the existing age brackets are still valid. No rule change has eliminated them. If the rule changes, everyone immediately loses benefits. Not true. Most updates apply only to new decisions made after their effective date. You may be grandfathered under the current system if your claim was decided earlier. Filing while the current rules are active may give you the best opportunity. Thank you for tuning in to this episode of our SSI and SSDI disability series here on Social Security Post. Today we covered what the grid rules are, why age 50 plus matters, what recent updates have already taken effect, what potential changes could be coming, and what practical steps you can take now to protect your claim. If you have a question about how these rules apply to your own situation, your age, job history, or limitations, share it in the comments. And if you found this helpful, please like, share, and subscribe for more updates on Social Security and disability benefits.